Response.
Your Honor, MCL 600.5735 sets the dates that the summary proceeding must occur after the issuance of the
How
summons.
long have you been doing summary proceedings? Because what's the date of that statute?
Um, it's been effective since it's at least amended since 2004.
Correct. And in 2020, particularly Supreme Court Administrative Order 2020-17 changed that, correct?
I would need to verify, Your Honor.
Yeah, you should have looked at that before you filed this response. Go ahead.
Your Honor, we largely rely on our response to the defendant's motion.
Yeah, but I've got questions regarding the response because what you put in the response, it seems to me to be frivolous regarding an argument for a motion to adjourn the trial date. You're indicating that the court doesn't have discretion, that there's got to be a hearing without any analysis of the original statute that provides for service and a hearing date from within the 3 to 10 day range. But that's when trials weren't held in the manner that they're held right now. And so I don't think that you necessarily, if you want to try to explain what all of this that's in here, then you might want to do so, because I consider many of the arguments that you make here absolutely frivolous and not taking into account the stat.
All right, guys. Today we are diving into a courtroom exchange that went from routine to explosive in seconds. What started as a simple response to a motion quickly turned into the judge openly questioning an attorney's legal knowledge in front of everyone. The moment the plaintiff tried relying on a statute, the judge immediately pushed back and exposed major flaws in the argument. You can literally hear the tension building as the courtroom atmosphere completely changes, and the attorney suddenly finds herself on the defensive.
Statutory and court rule changes that have occurred regarding summary proceedings.
Respectfully, Your Honor, again, our position is that the statute places a limitation on the adjournments and
Give me the court rule, by the way. Court rules will supersede statutes on procedural matters. That has always been the rule. So give me the court rule that does not give this court discretion to adjourn this trial.
Your Honor, under MCR 2.001, the court rule yields to the statute.
On procedural matters?
The language in 2.001 specifically states that the rules in this chapter govern procedure in all civil proceedings in all courts established by the Constitution and laws of the state of Michigan, except where the limited jurisdiction of a court makes a rule inherently applicable, or where a rule applicable to a specific court or a specific type of proceeding provides a different procedure. Our interpretation of that specific type of proceeding provides a different procedure read in conjunction with the Summary Proceedings Act, which provides.
Be kidding me. Read the first sentence again.
The rules in this chapter govern proceedings in all civil proceedings in all courts established by the Constitution and laws of the state of Michigan.
That's it.
In this part, the defense attorney calmly explains how the entire scheduling issue started after discovering his clients had already planned international travel before the trial date was set. But the real twist comes when he reveals that he repeatedly contacted opposing counsel through emails and voicemails and never received a single response back. What makes this moment important is how the defense frames the issue not just as a scheduling conflict, but as a matter of fairness and due process before the court.
The rules govern the procedure. So why didn't you, and also the rules do require where somebody reaches out to the opposing side that there is to be some type of either concurrent or not concurrent in a motion that's filed or a request. So why didn't your office respond to defense counsel's request? I'm not saying what the response has to be, but the very fact you didn't respond.
Yes, Your Honor. So while Mr. Ganyu, and I apologize if I misstated that, when he called me, I was in a client meeting, and then the email had already come in that he was moving to adjourn it. And so I didn't have the time to give him a call back and explicitly state that we weren't going to proceed with concurring, but my understanding or my position was a non-response is the same as not.
No, it is not. That cannot be your response. You're going to tell me when opposing counsel reaches out to you, even if you don't agree, that you have no obligation to respond? Is that what you're telling this court?
No, Your Honor. I was intending on originally giving him a call back, but the motion had already came through. I was in a client meeting when he called me.
Your Honor,
You're saying there wasn't a time between his original contact with you and the filing of the motion that you had no way of reaching back out via email otherwise to him? Is that what you're representing to this court? Be careful on your answer.
No, Your Honor.
That's not what you're saying to this court, because I really hope you're not.
No, Your Honor.
You have previously adjourned dates in this case, correct?
Correct, Your Honor.
And you sought the concurrence of defense counsel to adjourn those dates, correct?
Correct, Your Honor.
Then explain to me why you would not show the same courtesy.
Your Honor, we have shown the same courtesy. They also asked for 2 specific adjournments. And in this scenario, the client wasn't willing to give another stipulation to adjourn. We recently received body cam footage of recent calls out to the unit, and
Did that get filed with your response?
no, Your Honor, we actually received it via FOIA request yesterday. And so I was able to watch the body cam footage of what the noises sound like, which really puts into perspective the disturbance that this has caused the neighboring co-owners, which helped me understand why the client was not willing to allow me to stipulate to
When
adjourn.
did the supposed noises and everything occur?
The body cam footage that I received yesterday, I can give you the specific dates if you could give me one moment, Your Honor.
Yes, please.
So one of the body cam videos is dated 3/10/2026.
310?
This is where the hearing turns into a direct legal showdown between court rules and state statutes. The plaintiff tries defending her interpretation of procedural law, but the judge immediately challenges the argument line by line. At one point, the frustration becomes impossible to hide as the judge cuts her off and forces her to reread the rule aloud in court. You can feel the momentum completely shifting here because the judge clearly believes the legal research behind the response was seriously flawed.
Yes, March 10th. The other two of them are dated 4/13, and then there's one on 4/15, excuse me.
Daniel, you know anything about those?
I don't. I am happy to look into them, but I have not seen any of the body cam footage.
I just
Or-
received them yesterday, Your Honor.
Back to your motion. Did you even, I mean, I'm going to ignore your section 3 regarding the court rules and general discretion not overriding the Summary Proceedings Act, because I quite frankly don't think you know what you're talking about, because you haven't gone and looked at 2017, which changed everything. You also have not gone into looking at the way in which summary proceedings are now handled, and that they were specifically overridden by the Supreme Court regarding certain procedural issues, and then incorporated within the court rules that you say don't override particular statutes. And that's just wrong. I can't, it's just blatantly. And obviously, doesn't make any sense to me.
Things get even more uncomfortable in this section because the focus moves away from legal arguments and onto professional conduct. The judge directly questions why opposing counsel's repeated calls and emails were ignored. The attorney tries explaining that she was busy in meetings and assumed silence was enough of an answer, but the judge was not accepting that explanation at all. The warning to be careful on your answer instantly raises the pressure and completely changes the tone of the hearing.
If there are issues, certainly, that regarding the defendant's conduct that you become aware of between the time of a trial date and the time of the setting of that trial date, much like every time, and obviously you don't know how this court works, if you filed a request for an emergency hearing on it, this court would do everything to accommodate that. So if there are issues that are involved between the time of the trial date and that, court will address it. But in that regard, we don't practice law here in Washtenaw County by sandbagging. So if you've got evidence of something that is going on, you present that to opposing counsel, see if the resolution can be worked out. If it can't be worked out, you contact my office, you file a motion, much like what happened here. This court will accommodate it within its schedule and get you in to address whatever the issue is. We don't practice this way here, certainly not in this court. I am going to, for the time being, ignore this very poorly researched response. Quite frankly, I think what's in there and it's sanctionable. And I'm going to decline at this time to do that. I will take my request, because it's not going to be defense counsel's request. The request for sanction, I'm going to take that under advisement. So you need to understand, counsel, that doesn't mean that I will not, but I'm not going to at this point. I will also not award to defense counsel attorney fees and cost in this case, but I am going to adjourn the trial date. And I'm going to make it very clear, counsel, so that if you want a written order to that effect, then I'll give you a written order. I don't think it requires a written order. That if there is a circumstance where I find that opposing counsel is not responding, then I am going to sanction, and I'm going to sanction hard. That is not how one practices law.
Just when the hearing already seemed heated enough, a completely new twist enters the courtroom. The plaintiff suddenly reveals recently obtained body cam footage connected to noise complaints involving the property. According to the attorney, the footage helped explain why her client refused to agree to another adjournment. What makes this moment interesting is that the defense appears caught off guard by the new evidence, while the judge immediately starts digging into dates and details to understand what exactly happened.
Having considered the motion and the response for whatever the response is, non-jury trial in this matter will be adjourned. I will adjourn the matter to June 2nd, 2026, 9 a.m.
Thank you, Your
That
Honor.
is all. Mr. Gunn, you prepare an order to that effect, please. Thank
Yes,
you.
sir. Thank you, Your
Thank
Honor.
you, Your Honor.
This final part is where the judge fully takes control of the courtroom and delivers the strongest criticism of the entire hearing. He openly states that the response filed by plaintiff's counsel was poorly researched and even calls parts of it sanctionable. Then comes the most intense warning of all when the judge says he will sanction hard if attorneys continue refusing to respond professionally to one another. In the end, the trial gets adjourned, but not before the courtroom receives a serious lesson about legal professionalism and courtroom conduct. If you enjoyed this breakdown, make sure to like the video, subscribe to the channel, and we'll see you in the next video.